Module 4B is the general provisions of obligations. Excerpts are from the Law on Obligations and Contracts by De Leon. Welcome to CE Laws, Contracts, and Ethics. Article 1156 of the Civil Code states that an obligation is a juridical necessity to give, to do, or not to do. But first, let us define the meaning of the term. The term obligation is derived from the Latin word obligatio, which means tying or binding. Every obligation has four essential requisites. First is a passive subject, which we also call debtor or obliger. This means the person who is bound to the fulfillment of the obligation. He is the one with a duty. An active subject is also called creditor or obligee. He is the person who is entitled to demand the fulfillment of the obligation. He is the one who has the right. The third is the object or prestation or the subject matter of the obligation. This is the conduct required to be observed by the debtor. It may consist in giving, doing, and not doing. Without the prestation, there is nothing to perform. In bilateral obligations, the parties are reciprocally debtors and creditors. The last is the juridical or legal tie. It is also called efficient cost. It is that which binds or connects the parties to the obligation. The tie in an obligation can easily be determined by knowing the source of the obligation. In summary, two parties enter an agreement where one is called obligee and the other obliger. They are bound to do a certain object or prestation, evident in a legal tie. From the viewpoint of subject matter, obligation might be either real or personal, where the latter would be divided into positive personal obligation and negative personal obligation. When we talk about real obligation or the obligation to give, this is that in which the subject matter is a thing which the obliger must deliver to the obligee. For example, an individual obliges himself to deliver food to the poor. Positive personal obligation or obligation to do or to render service. An example would be one obliges himself to give therapy. Lastly, negative personal obligation is obligation not to do, which naturally includes obligations not to give. For instance, a person obliges himself not to pass a certain path. Article 1157 states that obligations arise from law, contracts, quasi-contracts, acts or omissions punished by law, and quasidelics. The sources of obligations are enumerated as first, law. These are obligations when they are imposed by law itself. For example, would be obligation to pay taxes or obligation to support one's family. Second, contracts. When they arise from the stipulation of the parties, just like the obligation to repay a loan or indebtedness by virtue of an agreement. Third, quasi-contracts. When they arise from lawful, voluntary, and unilateral acts which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of the other. In a sense, these obligations may be considered as arising from law. Example, the obligation to return money paid by mistake or which is not due. Number 4, crimes or acts or omissions punished by law. These are obligations that arise from civil liability, which is the consequence of a criminal offense. For examples, the obligation of a thief to return the car stolen by him, or the duty of a killer to indemnify the heirs of his victim. And lastly, quasidelics or torts. These are obligations that arise from damage caused to another through an act or omission, there being fault or negligence, but no contractual relation exists between the parties. An example, the obligation of the possessor of an animal to pay for the damage which it may have caused. Article 1158 states that obligations derived from law are not presumed. Only those expressly determined in the code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of the book. Legal obligations are those obligations arising from law. They are not presumed because they are considered a burden upon the obliger. They are the exception, not the rule. To be demandable, they must clearly set forth in the law, that is, the civil code or special laws. For example, the employer has the obligation to give the 13-month pay for his employees, but he is not obliged to give bonuses. Under Article 1158, special laws refer to all other laws not contained in the Civil Code. Examples of such laws are Corporation Code, Negotiable Instruments Law, Insurance Code, National Internal Revenue Code, Revised Penal Code, and Labor Code. Article 1159 states, obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. The article speaks of contractual obligations or obligations arising from contracts or voluntary agreements. It presupposes that the contracts entered into are valid and enforceable. A contract is valid assuming all the essential requirements are present if it is not contrary to law, moral, good customs, public order, and public policy. It is invalid or void if it is contrary to law, morals, good customs, public order, or public policy. Compliance in good health means compliance or performance in accordance with the stipulations or terms of the contract or agreement. Sincerity and honesty must be observed to prevent one party from taking unfair advantage over the other. Article 1160 states, obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1 of the Civil Code of the Philippines. Article 1160 treats of obligations arising from quasi-contracts or contracts implied in law. A quasi-contract is that juridical relation resulting from lawful, voluntary, and unilateral acts by virtue of which the parties become bound to each other to the end that no one will unjustly enrich or benefited at the expense of another. There are two kinds of quasi-contracts. The first is negotiarum gestio, which is the voluntary management of the property or affairs of another without the knowledge or consent of the latter. Let's take an example. Suppose that persons A and B are neighbors. In one summer, A took a vacation with his family without leaving somebody to look after his house. While they are away, a big fire broke out near the house of A. Through the effort of B, the house of A was saved from being burned. However, B incurred expenses. In this case, A has the obligation to reimburse B the said expenses, although he did not actually give his consent to the act of B in saving his house, on the principle of quasi-contract. The second is solutio in debity, which is the juridical relation which is created when something is received when there is no right to demand it and it was unduly delivered through mistake. The requisites are, first, there is no right to receive the thing delivered, and second, the thing was delivered through mistake. Let's say that Chris borrowed money from Danny. If Chris paid Tom, believing that Tom was authorized to receive payment for Danny, the obligation to return on the part of Tom arises. Article 1162 states that obligations derived from Quasidelics shall be governed by the provisions in the Civil Code and by special laws. The above provision treats of obligations arising from quasidelics or torts. A quasidelic is an act or omission by a person which causes damage to another in his person, property, or rights, giving rise to an obligation to pay for the damage done, there being fault or negligence, but there is no pre-existing contractual relation between the parties. For example, while playing softball with his friends, a man broke the window glass of a neighbor. The accident would not have happened had they played a little farther from the house. In this case, the man is under obligation to pay the damage caused to the house of his neighbor by his act, although there is no pre-existing contractual relation between them because he is guilty of fault or negligence. There are different distinctions between crime and quasidelic. First, in crime, there is criminal or malicious intent or criminal negligence, while in quasidelic, there is only negligence. Next, in crime, the purpose is punishment, while in quasidelic, indemnification of the offended party. Third, crime affects public interest, while quasidelic concerns private interests. In crime, there are generally two liabilities, criminal and civil, while in quasidelic, there is only civil liability. Fifth, criminal liability cannot be compromised or settled by the parties themselves, while the liability for quasidelic can be compromised as any other civil liability. And lastly, in crime, the guilt of the accused must be proven beyond reasonable doubt, while in quasidelic, the fault or negligence of the defendant need only to be proven by preponderance of evidence.